Still on Abronye and his bail conditions. Yanko na sa semno. Yanko ti bibia akwa akudu.
Now, lawyers of NPP's Bono Region Chairman Kwame Bafo, popularly referred to as Abronye DC, are seeking a variation of bail conditions for their client. Abronye is on a 100,000 cedi bail with 2 sureties to be justified. He's also to deposit his travel documents with the court registrar and report to the police CID every fortnight. He is facing charges of offensive conduct conducive to the breach of peace and publication of false news over alleged derogatory remarks against a circuit court judge. Earlier, the presiding judge at the circuit court cautioned counsel for Abronye, who raised objections to court proceedings which they noted were incomplete.
So that is Abronye na yedinira.
Let's connect now with Lord Eduasare, who's a court correspondent on this matter. Lord, what else can you tell us about the attempt to vary the bail conditions for Abronye? Did it work?
Unfortunately not, Kemini. So basically, Abronye and his lawyers came to court today seeking to vary the bail conditions. We understand has to do with him depositing his travel documents to the court registrar. In the bail variation application, which is yet to be moved, they are seeking that his passports and travel documents essentially be released to him for medical reasons, among other things. Now, when the case was called today, the court indicated that they had just been served with that, with those processes, and then the prosecution in the matter had also indicated that they had filed an affidavit in opposition, which they had also served to the court. So the court asked that they will have to adjourn the case to basically assess and go through the documentation of the processes which has been filed by the lawyers for Abronye as well as the prosecution. And so the case is adjourned to Thursday for the motion to be heard and then ruling on the matter. But even before the High Court case, there was a bit of drama at the Circuit Court. You remember that Abronye was remanded into BNI custody over charges of publication of false news and then one other charge that has to do with stirring up the public with regards to making alleged derogatory remarks concerning a circuit court judge. Now, Abronye was before that circuit court judge, and then the lawyers raised issue with court proceedings from the last time they were in court. Now, this was their case. They indicated that the last time they were in court, the circuit court judge had, in his ruling, had indicated that Abronye be remanded into BNI custody until the final determination of that matter. Now, the initial ruling was that he would be remanded into prison custody, but the lawyers appealed that and pleaded with the court, and so that was changed to BNI custody. Now, this was what the lawyers say they had, but when they were served the court proceedings of the day, that portion of the ruling indicated that Abronye was to be remanded into BNI custody until the next adjourned date, essentially meaning that he was supposed to be having remanded for 2 weeks. Now, they raised objections to the court proceedings, essentially alleging that the details that happened in court was not what was captured by the court proceedings. Now, the presiding judge in the matter took that indication that the allegations they were making were in that amounted to forging judicial or court documents, and that has serious implications. Now, because of that, the judge then caused the clerk to bring back those proceedings, and then he read it in open court. Now, in open court, it came out that the ruling had to say that the Abronye be remanded into BNI custody until the next adjourned date.
Well, it would appear we lost Lord Eduasare on that connection to court, but we can take a listen to Abronye and his lawyer. Here, take a look.
Sebeya obinya adagya hwehwe all the documents I have filed so far. Zinyambwa will come back on Thursday.
In court today, my lord referred to the court record and the objection we raised with the court as to the incomplete nature of the record of proceedings as we received. My lord raised that, on the record, there was nowhere that they indicated that the accused person was remanded into custody until the final determination of the case. My lord has admonished that we rectify the issue with the registrar. And now, as I said, I'm counsel on record, and my legal team has.
Well, Lord Edwasari brought us that report from court, but we'll stay there because former Western Region Minister Kwabena Okyere-Darko-Mensah has been discharged by the court after he testified as a third defense witness for former MPP Ashanti Regional Chairman Wontumi. Among other things, Okyere-Darko-Mensah admitted during cross-examination that he was unaware of the conversation between Wontumi and Henry Okumi, who is the prosecution witness number 2, which resulted in the latter mining on his concession as Samre Boy. Lord Edwasari reports.
Bernard Enchi-Boisiakon, also known as Wontumi, is facing charges of assigning mining rights without the approval of the land minister and facilitating illegal mining operations on the Samra concession in the Western region. Former Western Regional Minister Kwabena Okyere-Darko-Mensah, who also served as chairman of the Western Regional Security Council, told the court during his testimony that a formal complaint was received from Akonta Mining about the invasion of illegal mining operators on Wontumi Samra concession. He affirmed that the complaint was written and documented and was urgently acted upon by the Security Council, as it was consistent with several complaints from other mining rights owners in the region about organized criminal groups invading concessions and carrying out illegal mining. During cross-examination by Deputy Attorney General Dr. Justice Fremsai, the former minister, who served from 2017 to 2025, disclosed that he did not personally know the prosecution's second witness, Henry Okum, the individual who testified that he was commissioned by Wontumi to mine on his concession. Henry Okum had further told the court that Wontumi did not produce any formal mining rights. Asked about the engagement between Okum and Wontumi, Darko-Mensah indicated that he was unaware of the interaction between the small-scale miner and the NPP Ashanti Regional Chairman. Lead counsel and the Apia Kubi expressed satisfaction with the outcome of the testimony.
Was to indicate that it was rather Chairman Wontumi and his company that made reports to his office as then chairman of the Western Regional Security Council, and that all efforts made by the Security Council to ward off illegal miners and also to redeem or reclaim the lands so degraded by illegal mining were at his instance. So today's evidence sits very well with our own, and indeed it exonerates people who engage in reclamation of degraded lands.
Defense lawyers are set to call their next witness on Wednesday, June 3.
Adafunum yetie the ekoso ewo court dem efa Abronye nsem ho ani chairman Wontumi nso ede Samra Boy concession no nsema ekokokoso ho no update bia yensa beka biem no se besan so atenase ne de ababe som na monso ye ekoso ewo Ghana mamu hanom bia no yama ohun ye eko yemfa monsi hanom se ye besan so ehia biem in the next video. Akram.